Thank you. Can I welcome everyone to the Justice Committee's 22nd meeting of 2013 and ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with the broadcasting system even when switched to silent. We received apologies from Jenny Mara, and I take this opportunity to welcome Elaine Murray and perhaps later John Pentland, who, subject to the Parliament's approval, will be joining the committee this evening at decision time. That's if they like what they see. And thank you for coming along today. And they'll be placing Jenny Mara and Graham Pearson. Can I say that Jenny and Graham have been very excellent on the committee, and we'll miss them both. And can I also say, with leave of the committee, a few words about David McLetchie and pass, if I may, the committee's condolences to his wife, his son James and the rest of the family. I think the committee would agree we'll miss his robust interrogations, his humour, his mischief, and personally I'll miss his impromptu duets, though unfortunately, or fortunately for you, they didn't occur during meetings of the Justice Committee. But I hope we would all want to pass that on to his wife and family. Thank you. Item 1, European Union legislative proposals. The first item is consideration of whether 2 EU legislative proposals comply with subsidiarity principle. These are a proposal for a Council regulation of the European Parliament and of the Council on the establishment of the European Public Prosecutor's Office. That's 12558/13, and a proposal for a regulation of the European Parliament and of the Council on the European Union Agency for Criminal Justice Cooperation, Eurojust, 12566/13. We've only one opportunity to consider these proposals, and that's why the EU reporter, that's Roderick Campbell, and I agreed it would be helpful to hear from the Cabinet Secretary today. So I welcome to the meeting Kenny MacAskill, Cabinet Secretary for Justice, Kevin Philpott, Senior Policy Officer, Criminal Procedure Policy Unit at the Scottish Government, and David Dickson, International Cooperation Unit at the Crown Office and Procurator Fiscal Service. And I thank you for agreeing to come at short notice. Can I also thank the Cabinet Secretary for the additional letter we had regarding the Cabinet's position or the Government's position with regard to these proposals. And can I ask you, Cabinet Secretary, if you wish to make a brief opening statement on both proposals before I open it up to members' questions?
Yes, thank you, Convener. Can I first of all put on record on behalf of the Government and echo your comments both regarding David McLetchie especially, but also regarding Graham Pearson and Jenny Mara. As you're aware, the Scottish Government brought an issue of subsidiarity to the committee's attention, and I hope to give you some indications of the Government's thinking on that, but I'd also like to give you some information about aspects of policy and proportionality. You'll have received a letter from me outlining the Government's thinking on these issues, and I appreciate the timing has not been altogether conducive to examining these issues, so I hope that the letter and what I have to say this morning will help. The instruments are closely linked. The proposed European Public Prosecutor's Office would work out of the reformed Eurojust, and the reforms to Eurojust are in considerable measure about providing the framework to allow it to do so. As I say in my letter, subsidiarity is defined in Article 5 of the Treaty of European Union, and I quote, "The Union shall act only if and insofar as objectives of the proposed action cannot be achieved by the Member States, either at central level or at regional and local level, but can rather, by reason of the scale or effects of the proposed action, be better achieved at Union level." Starting with the EPPO, the Commission believes that there is a major issue of fraud against the EU budget. Tackling this is given added impetus by the current financial crisis, and you'll have seen from the UK Government's explanatory memorandum that they consider the identified fraud of about 425 million in each of the last 3 years is actually the tip of a 2.55 billion iceberg. It is uncontestable that something needs to be done about EU fraud. However, the proposed action raises serious subsidiarity concerns. You'll have seen these in the UK Government's explanatory memorandum, but it is worth repeating the core of these concerns. This is that the Commission has moved directly to creating a new supranational EPPO with extensive and harmonised powers. There's no consideration of whether less abrupt changes, such as prevention or deterrence at source, might be as effective and certainly a great deal cheaper. Even if we take the Commission on their view that a high prosecution rate is a way to deal with fraud, it is clear that the move to an EPPO is premature. In 2011, the Commission suggested that national prosecution authorities had conviction rates of between 14% and 80% of cases transferred by the European Anti-Fraud Office. and that's OLAF. It is clear from the Commission's own figures, then, that some Member States are achieving high prosecution rates. The correct course of action, in line with the principle of subsidiarity, would be to recognise that some Member States are effective, so that what was needed is not a new EPPO, but an effort to help all Member States reach the high levels some of them have already achieved. Turning to the Eurojust proposal, we acknowledge that Eurojust is already a feature of the landscape. We believe it's a successful one. That is certainly the tenor of the recent report, the 11th annual report, in which the organisation is said to have reached cruising speed. That being the case, one might wonder why now is the time to jump out of that vehicle and into a rebuilt one. The specific subsidiarity concern with the Eurojust proposal is in the powers given to national members. As currently constituted, these allow national members to initiate investigations, and I quote, in agreement with the competent national authorities, end quote. The reforms would allow national members throughout the Union to initiate investigations themselves in defined and inverted commas urgent circumstances. No effort has been made to establish whether the objectives could be better achieved by continuing with the existing arrangements, which are more respecting of national and local jurisdictions. Indeed, you'll have seen that any kind of bespoke impact assessment is missing. In these circumstances, we do not see how the subsidiarity case for the departure from the existing model is made. And of course, where there are subsidiarity concerns, there are also likely to be proportionality ones as well. According to Article 5, subsection 4 of the treaty, and I quote, under the principle of proportionality, the content and form of union action shall not exceed what is necessary to achieve the objectives of the treaties, end quote. Considerations here are whether the union measure have left as much scope as possible for national decision-making, and whether the proposals respect well-established national arrangements and the working of Member States' legal systems. It's clear that there are difficulties with each of these considerations. At the heart of our policy position is our system of prosecution, and in particular the position of the Lord Advocate at its head. Decisions by the Lord Advocate are to be taken independently of any other person. The proposals for EPPO and for the reform of Eurojust trespass directly on that position by granting prosecutorial powers within Member States to the EPPO and by allowing national members of Eurojust to direct investigations. These are proposals. Ahead of them lies a period of negotiation, so it's too early to say what the final position will be. In particular, the UK government has made very clear that it does not intend to take part in the EPPO. This is stated at several points throughout its memorandum. However, the proposals give considerable cause for concern, and I believe members will understand our policy position and the difficulties raised by the Commission's proposals. The UK Government's explanatory memoranda set out that there are issues in respect of which both proposals fall short of satisfying concerns on subsidiarity. We would agree with that assessment, and I hope I've helped you with the background to why we've taken that view.
Yes, and it's certainly robust compared to, I think, to what I was expecting in the letters. That's just a comment of mine on it, but that's quite a robust one. Roddy, do you want to come in first as European reporter?
Yeah, morning, Cabinet Secretary. Could you expand on what was said in your, I think, in your initial letter, that there was little or no evidence that consideration had been given to the possibilities short of the creation of a new supranational agency in relation to the EPPO? What evidence have we seen, you or your team, of the Commission's investigations?
Mr. Philpott.
The point is we haven't seen any evidence of any kind of intermediate step between the current position and the position of the all singing, all dancing EPPO, if you like. There's been no examination of anything less than the full measure proposed in the proposal there.
So in terms of the Commission trying to persuade you, let alone this committee, that they've considered alternatives, you would say that that position has not been proven?
That's very much our position. There is no evidence of an intermediate step. There's no evidence, well, we acknowledge there might be a subsidiarity problem. A subsidiarity issue would be is there something less than this that would achieve the objectives and would be in keeping with national and local measures? So let's examine something less than the entire EPPO proposal, and there's no examination of that at all.
Okay. In relation to the Eurojust proposal, the UK government's not reached a final view.
Can I come to that after? Just
Okay,
let's deal with
sorry.
the EPPO
Okay,
first.
right.
We'll deal with that first, and then just for the sake of the
Okay.
OR, but I'll come back to you. Yes, EPPO.
You made mention of the success rates across Europe in terms of prosecution in relation to the frauds. I don't see any reference to the numbers of cases transferred to the UK as a member state, and further no indication of cases within Scotland. Do we have any knowledge of the numbers of cases transferred and our own success rate in that regard?
I think the impact assessment has indicated there was something in the region of about 25 cases with the UK. In relation to Scotland, there have been very few, and there's currently one, and that's the position presently.
Yeah, and I think I'm rehearsing, but for the record, it would appear to be that we haven't actually identified where the nub of this fraud difficulty lies in terms of member states. If we're talking about one case currently in Scotland,
Yes.
It's a very small nut we seek to crack by these arrangements, it seems to me.
Well, the evidence seems to indicate that what the European Public Prosecutor is being established to tackle is fraud in the European budget, and it is the European budget or the budget of the institutions. But in terms of percentage, it represents 0.5% of that budget. So even within that context, it's not, I would suggest, a huge figure. Clearly, fraud of any type has to be tackled.
Yeah.
But while the figure itself is significant, as a percentage of the European Union's budget, it's not a significant suggested amount.
Okay, thank you.
Can I just ask how you know it's 0.5%?
It's just it's in the evaluation, it's in the impact assessment. And
But how do they know if they've not uncovered all the fraud? How do they know how much?
Oh, well, that's the recorded fraud is round about between 400 and 600 million, depending on which.
So it's just 0.5% that they know about?
Of what they know about. And
could be
I
a
think
lot bigger.
it suggests it could be as high as 2.5 billion.
Okay, thank you. John?
On the paragraph 7 of the explanatory memorandum, there's a statement I'll read to you, please. The Commission believes Member States are not able to satisfactorily to identify, investigate and prosecute EU fraud. And I wonder if there have been any representations made to the Scottish criminal justice system in advance of what, for me, seems to be an over-the-top draconian proposal here. Have there been any representations made about the ability to identify, investigate or indeed prosecute prior to this? Whether David, you can assist from a prosecutorial point of view.
I'm not aware of whether there has been any direct contact in relation to that. Clearly, what there has been is the history of this proposal rests back in the 1990s, and it, to that extent, has been resurrected given the current economic situation. There was an evaluation, a study carried out by the University of Luxembourg, which looked at all member states' approach to how they tackle fraud, how they deal with fraud in the European budget, which identified this wide, it said, discrepancy between some member states which will take up every case which is referred to them, will investigate and will prosecute. Obviously, conviction is is never guaranteed, it's a different issue, but again, divergent levels of conviction, but also within that, a different approach in relation to the investigation of cases. However, of course, what underlies this is the fact that we are dealing with currently 30 different legal systems. And of course, each member state has different rules of evidence, have different rules of how to establish guilt and so forth. And of course, the Commission's position is, well, the only way we can deal with that is in fact to have a supranational body with rules of evidence which are across the board, across all member states, because what also lies as part of this proposal has been drafted model rules which will deal with effectively the criminal procedure and evidence. So it's effectively an attempt to try and overcome all of that, but it is a severe criticism of member states' national systems. And as Kevin says, there's not, despite the study, there's not really been much evidence to say that it's so defective that it requires a supranational body?
And I should say that we have not had any communication from them, and certainly from a governmental point of view, we do believe that the prosecutorial system in this country does work well on these matters where it does happen here.
Yes, so what you're saying is it goes far beyond just administrative and policing. We're talking about changing rules of evidence or applying different rules of evidence against other jurisdictions that have their own systems, complete with different ways of determining guilt and balance and juries and whatnot. Sandra.
Thank you very much, Chair, and good morning, Cabinet Secretary and gentlemen also. To follow on from John's question, just to move it on slightly, I'm also concerned in regards to the powers that may be transferred if this was to go ahead. The Cabinet Secretary mentioned the fact that some Member States have been very effective, and obviously with the fraudulent, but you mentioned yourself in regards to Scotland, it's very small, and other Member States should be given as much help to be as effective as others. I just wondered if the Scottish Government or the UK Government have put forward this type of idea to look into helping the other Member States rather than using this huge big body. It seems like a very, very difficult issue to tackle when there's some Member States who are effective and others aren't. I just wonder if there's any communication between the Scottish Government to the UK Government, the UK Government to the EU in regards to looking at individually helping these Member States to be as effective as others.
I think we should put on record that Eurojust, as far as we're concerned, does work well, as does do other matters such as Europol, and certainly whether through the law offices of the law officers or whether through ourselves as a government, whether through UPREP or whatever, we believe that it's important that we do cooperate at that level. We do believe that we are contributing, and we do believe that there may be issues, but there are issues to be tackled elsewhere. It's not simply in this area where there are matters. I think we know that in terms of information relating to previous convictions, some European states are much better, and occasionally in Scotland we've had difficulties because that information is not necessarily available nor able to be accessed by us. But where we're coming from as a government is that we fully support cooperating in these matters to address, fraud. That is unacceptable. We do believe that the justice forces that we have, whether government, whether through the independent law officers, through the Crown and Prosecution Service, are capable of providing that. They will continue to fully cooperate, but the current proposals, we share the concerns of the UK government that this would cut across the offices of independent Lord Advocate and would, as I say, result in perhaps difficulties as a different jurisdictional view is perhaps taken in a system where we have our own legal views.
Right. If you've got some, you want to ask something else, I'm going to move on to the next part.
Just a final question would be that, yes, obviously we explained the fact that we do have concerns in regards to that. Would we be writing to the EU or the UK government with these concerns and asking if it would be possible for other... That's what the committee... Oh, sorry.
That's for us to decide.
Right, sorry, I've overstepped the mark.
What the Cabinet Secretary does is his business. Sometimes we like to know as well, but no, we'll make up our mind what we want to do. We want to move on to the next bit. I've cut you off there on Eurojust, Roderick, the second proposal.
And the UK government has yet to reach a final view. Are you able to tell the committee, have we had any recent discussions with the UK government in relation to the Eurojust proposals themselves? Have we got any indications to their thinking?
Yes, I have had some recent discussions with colleagues of the UK government, and no, they haven't indicated any final thinking that they might have on what they intend to do about it. Okay. But we are in very, very regular touch about that, and indeed there's a conference call arranged tomorrow.
And we really have no idea as to the investigations in undefined urgent areas which is being proposed, what that's to cover, or have we?
No, we don't. Hence it remains undefined.
Yeah. And to that extent, how does that satisfy the subsidiarity principle?
Well, that's exactly the question. We have no way of addressing how that would address the subsidiarity principle. As long as these undefined urgent matters remain undefined, I mean, urgent could mean quite a lot of things. That's possibly more of a proportionality than a subsidiarity question, but as you know, they're very closely linked.
Yeah, okay, thank you.
Any other questions on that? Yes, Graham.
Just one question. I kind of struggled reading the papers over the weekend to understand the extent to which one proposal relates to the other and how much they rely on each other. If we find that one proposal falls in relation to subsidiarity, how much impact does that have on the other? Are they so closely interlinked that it has impact, or do you see them as completely separate issues?
There is clearly a link between the two, especially when you consider the introduction and the papers on the proposed directives, where it does, for example, talk about Eurojust's fraud cases,
Right.
which I think in itself is quite a significant phrase. Eurojust's fraud cases, as opposed to fraud cases reported to Eurojust by the member states, will be transferred to the European Public Prosecutor's Office. So there is a link, but clearly, as far as the law officers are concerned, that Eurojust does play a valuable role. And within the current structure of Eurojust, which is currently being evaluated by the Council, with visits to all member states to see how the member states currently engage with Eurojust under the most recent decision. And it has been suggested in various places that this Eurojust proposal is perhaps a little premature, since it's still being evaluated, the current situation. But there is a mechanism within Eurojust which actually can deal with all of these issues. It ideally would be standalone, because clearly it has direct substantial benefits to us as prosecutors.
It seemed to me, reading the two separate papers, that if one was to engage in some kind of transnational investigation of fraud, then Eurojust would necessarily need to change this method of governance in order to oversee this new capacity. And I was trying to unpack that in my mind in terms of if we decide that subsidiarity concerns proportionality in terms of the fraud, it leaves an awful lot more time to reevaluate the Eurojust element in its own case. But they're presented as two separate issues, which the spaghetti's there, it's trying to separate it out, which is quite difficult in making these decisions.
It's an issue which is going to perhaps concern a lot of jurisdictions, because the proposal can only be taken forward if there's unanimity, which feeling there could be there could be enhanced cooperation if at least 9 member states agree to the proposal. And if that was to happen, then of course clearly there are different levels of how the organisations would interact with those, and that could. I'm not trying to avoid the question, but it could be extremely difficult to see how an organisation which is valuable and works would interact with an organisation which perhaps only half of the member states have signed up to.
That's right. Okay.
So Eurojust itself would have to find a mechanism, as would the member states' national desks, in which they could operate within that. But clearly what will still exist in some form is Eurojust with the national desks and a gateway where we can approach as prosecutors to gain assistance across borders.
No, I'm grateful for that. Thank you.
Thank you. And I'm going to say the fatal words. I see no more questions being asked, because when I say that, something usually comes in. So as there are no questions, can I thank Cabinet Secretary and your officials for attending? And I'm now going to move straight on to Decisions Committee with regard to each separate proposal. And the first would be the EPPO. And if you look at page 3 of paper 2, please excuse me just for battering on. We've a lot to do this morning. We're going straight on to everything. That's because of you, Cabinet Secretary, and all these bills that you give us, all these witnesses coming. 3 options are provided on page 3 of paper 2. The first is to agree the proposal does comply with the subsidiarity principle. The second is to agree the proposal does not comply, and this decision would trigger a motion in Parliament. And the third option would be to agree that there are concerns that the proposals may breach the subsidiarity principle, and to write the relevant Westminster committees highlighting these concerns. Now, can we just focus on the EPPO first of all? And Roderick, I'll bring you back in first of all to give your views.
I think in the light of all that's been said, in the light of the UK government's position also, and what we've seen from the Scottish Government, I take the view that the proposal doesn't comply with the principle of subsidiarity. That's
Does
my view.
anybody disagree with that? I think we can move on if we've all taken that view on that. I think so. So this will trigger a motion in Parliament, and it doesn't necessarily have to have a debate. We will put a motion down which will be heard this week. This week. There you are, there you are. Take your chairs again for another session on it. But I think, thank you very much. The next one is the decision to establish a European public, I beg your pardon, the second proposal which forms Eurojust. Again, Roderick, can we take your views on that one?
I find that this one a bit more difficult
Yes.
to assess, and I take the words of the government official who said it was a premature proposal. I kind of think it is, and it's quite difficult to separate out subsidiarity from proportionality. But because we don't know what undefined urgent cases are, it's really, it's a kind of a borderline one. I'm not sure that I take quite as strong a view as I do with the EPPO. I'm sure if there is a halfway house as to what we could do, possibly just voice concerns about it rather than putting a specific view.
Does anybody take a different view from Roderick on that? I think we're all pretty well with you on that. I agree with that. So we could say it may breach the principles of subsidiarity. We could write the relevant Westminster committees highlighting our concerns, and also the fact that insufficient evidence, and so we could thread that in, and it seems a bit hurried to me and opportunistic rather than having been thought through. So we will write to the relevant committees in that one, make a distinction.
I think perhaps we ought to note that was it Mr. Philpott who said he was having a conversation with the UK government tomorrow, that we could perhaps be advised of the outcome of that conversation.
Would you be happy for the letter to be drafted with my name and from Roderick to give it the once over? Okay, thank you very much. Right, I'm going to have a brief suspension, a couple of minutes simply to allow the next panel of witnesses to sit down, so stay in your seats. Thank you very much. I welcome, next is our first evidence session on the Tribunals Scotland Bill, and today we'll hear from two panels of witnesses. And I welcome to our first panel May Dunsmuir, Convener Additional Support Needs Tribunal for Scotland, Heather Bailey, In-House Convener Mental Health Tribunal for Scotland, John Wright QC, Lands Tribunal for Scotland, Alistair Beattie, Convener at Scottish Valuation Appeal Committee Forum. Can I thank you all for your written submissions? Just to let you know we do our homework. We have them all here. And can I also tell you that if you just indicate, members will ask questions that you want to respond, your microphone will come on automatically. That's the plan anyway, but we're all a bit rusty having been off for a few weeks. Can I just ask members for questions then, please? The usual, just indicate and I'll put you on my list. And for the sake of Elaine, I have two lists, Elaine. A, for primary questions, and B, supplementaries. So just let me know if it's a first question or a supplementary. Right, questions, please. John.
Thank you. Good morning, panel. The bill is about establishing a framework for reform. And I suppose my question is whether you share my concerns that whilst on the face of the bill there is talk about reform, but the detail is not within the bill, it's going to be left for another time. Do you share my concerns?
Mr. Wright.
Yes. I think one can appreciate that in a bill of this sort there would be quite a lot of need for delegated powers. But I think on central matters like whether particular tribunals are to be in or out, it really would be preferable for the Parliament to make that decision in the bill. So yes, in relation to the Lands Tribunal with which I'm concerned, I would share that concern.
Ms Bailey.
I think in relation to the Mental Health Tribunal for Scotland, a great deal of comfort has been taken from various undertakings in the memorandum, the policy memorandum, particularly in relation to the chamber structure. That concern has been addressed to a certain extent, albeit the memorandum refers to the Mental Health Tribunal going into a separate chamber initially. So there would be a concern in relation to future, and there would be a hope that there would be consultation at very least should that change.
Mr Beattie, you wanted to come in.
I share the views of the other witnesses on this, but it's also in relation to, as well as the points they've highlighted, the onward appeal arrangements, that the default is that appeals on points of law against decisions of first-tier tribunals would be to the upper tribunal. But it's already been said as a matter of policy intent that appeals on certain matters, for example, from the Mental Health Tribunal, would still go to the Court of Session. I think that is right. I think in our own case and the Lands Tribunal's case, it would also be right, as the Lord President has suggested, that appeals should continue to go to the Lands Valuation Appeal Court. But all of these are fairly significant matters that I think ought to be established from the start in primary legislation, and Parliament ought to have the opportunity to consider in the first look at this.
Sean Finney, is it on the same line, or is it something?
A generality, maybe an opportunity for the witness to expand.
Yes. Can I just say, but before you do that, because I'm looking at the Lands Tribunal thing, and you're really tough. You say in the 1, 2, 3, 4th paragraph number 2, the new system is not fatally flawed, simply an unnecessary attempt to demonstrate modernisation. That's the Lands Tribunal for Scotland, that's yourself, isn't it?
I think that's the response submitted by Lord McGee on behalf of the Tribunal.
Yes.
Yes.
You don't sound very, it's a very good idea, any of this. And
well,
it's threaded through it. I mean, your whole submission is pretty, as far as the Lands Tribunal is concerned, as you see yourself as special.
Yes, I endeavoured to encapsulate certain matters in my individual submission, but certainly I would suggest that matters of overall policy are not for us, but we do have concerns in relation to the Lands Tribunal, because we think that while it is entirely appropriate to consider reforming, changing, rationalising a system of tribunals which is developed on a piecemeal basis, we're not at all sure that we fit into this scheme. And I think that's a point which others have made. And the slight difficulty with the scheme of this bill is that you're either in or you're completely out. There are lots of good things in this bill for lots of tribunals. I, of course, am only dealing with the Lands Tribunal. There are lots of good things in it, but you only get the benefits from the bill if you're completely in it, if you're actually taken into the unified tribunal scheme, which is at the heart of this. And it may be that there are some bodies, and I would suggest that the Lands Tribunal for Scotland is one, where really, when you take a careful look at it, you see that we don't really fit in with the scheme. And to that extent, the bill appears to us to be difficult.
Can I just perhaps, I'm just to press on this, because you go further at page 11, paragraph 11 of the submission. We think that to aim for common standards and procedures, including review and appeal, as a significant plank of policy, risks creation of a serious impediment to identifying the most efficient way of serving the different needs of individual users. So you go beyond this, doesn't suit the Land Tribunal, to just say this about the bill at large.
Yes, well, that's within the submission of Lord McGee on behalf of the Tribunal, so it's not for me to to...
Oh, right. I thought you were...
It's not,
I'm so sorry. I thought you were going to speak to this paper.
Well,
I'll leave you to think about it.
I don't think it's right for me to come and, me as an individual member of the tribunal, to come and criticise the overall policy of the bill.
Right.
But I do appreciate that a response has been put in on behalf of the tribunal itself by its president. I did try to focus matters in a paper more particularly relative to the Lands Tribunal itself.
It's the fact that it says we think, I thought, on behalf of, you see, I thought that I could just ask it. Because it seemed to me
I appreciate that. Well, I mean, there are certain views about this bill as a whole, but it's not so much the some of the detail in the bill, it's the idea of an overarching unified tribunal. I think there are views that that is problematic. But as I say, I'd really rather come and deal with the matter which is properly within my field.
Well, I'll need to ask Lord McGee then what was meant by that, because that seemed to me to be that this seemed to be the paper that had the biggest go at it. And you know, I mean, I appreciate the range of views, and there was pluses and minuses through from all your submissions, but this was the one that seemed to me the tough cookie. And that's the good one. That's not saying the others aren't good, but that's the one that you really test it. Anyway, back to you, John.
You're obviously peeking at my notes because you used exactly the phrases I was going to use on each of the occasions. So I'll pass it this time and come in another point further on.
Okay. Sorry about that. It's just that I thought we'd missed that one, Roderick.
Morning, panel. Perhaps I'd just put on record register of interest as a member of the Faculty of Advocates. Notwithstanding what you said, Mr. Wright, I would just like you to direct you to paragraph 13 of Lord McGee's submission, and perhaps it would be helpful for the committee if you could expand on the differences as you see it between what's happening south of the border in relation to the Lands Tribunal in England, and in what respects you see the Lands Tribunal in Scotland as being in a different position.
Yes, primarily the Lands Tribunal of England and Wales was, or is, or was, substantially an appeals body. It dealt, not entirely, but to a large extent it dealt with appeals, particularly, for example, within the field of valuation appeals, with which Mr. Beattie is also concerned. So it, therefore, might be seen to, and obviously was seen to have a position within an upper tribunal scheme, although it was made a completely separate chamber. And I appreciate that's the policy of that is indicated in the policy memorandum here in relation to the Lands Tribunal for Scotland. But the first thing is that it was substantially an appeals body. The second thing, I think, is the volume of cases generally in England and Wales. You can have, in a system where there is such a large volume of appeals as there is in England and Wales, overall, I'm talking over the whole field, it is easy to imagine splitting your upper tribunal up into a number of different chambers. But as I think the Lord President has said in his response to the bill here, the idea of splitting up the upper tribunal in Scotland, which is dealing with this very tiny number of appeals. I know there's a particular situation in relation to the Mental Health Tribunal, but generally the idea of having an upper tribunal dealing with a small handful of cases and then dividing it up into divisions and chambers, we don't really think that that is a particularly sensible way of going about it.
In relation to kind of what we touched on in the previous investigation committee in relation to expenses orders at the Lands Tribunal, have you any views you care to share with us about the uniqueness of the Lands Tribunal's approach to expenses as opposed to what's proposed in the bill?
Well, I think this is quite a good matter to illustrate one of the general points here, which is the extent to which you have to change the general provisions in the bill in order to fit the particular situation within particular tribunals. Now, as far as the Lands Tribunal is concerned, I'm well aware, of course, that this committee was looking at one particular jurisdiction, one of our jurisdictions, in relation to title conditions, where there was a particular provision in the 2003 Title Conditions Act which was causing a problem. But actually, we have several different jurisdictions. We have a different rule in relation to expenses for compulsory purchase compensation. There's another different position in relation to expenses for valuation for rating cases. So if you're going to bring us into a general scheme which has a general rule about expenses, you have to take account of all these various different things. And I'm not saying it's impossible to do. You can make all the changes that would need to be made to bring the Lands Tribunal in, but it just seems somewhat inappropriate to do so. We have, in effect, if you take our general position about expenses, and then you take those three particular ones. Within our various jurisdictions, we have about 4 different rules in relation to expenses. And it is difficult to see all these matters being dealt with appropriately in the context of a general overall reform. But I do stress with respect that I am here speaking particularly about the Lands Tribunal. I mean, other tribunals are in,
yes,
will be in different positions.
We'll leave you alone in a little while, for the time being. I know it's very odd to be in the side of questioning when you're usually doing the questioning yourself. I've been there myself. Are we going to ask about another issue? We can come back to the Lands Tribunal. I'd like to give it... Excellent.
It's not the Lands Tribunal per se. It's an absolute general question for everyone to answer it as they feel they want to. Just general question, where are the proposals in your eyes and your organisations? Do you think it's an improvement on the structure that you have at the moment?
I think as far as the Mental Health Tribunal is concerned, the structure that we have currently works well, but we recognise that we can work within a different structure and we can see benefits in terms of savings, having a general administration. Our anxiety, however, is to maintain our particular ethos, our patient-centred approach, and the very special parts of the Mental Health Tribunal that make it a success. Given that this proposal, this bill, does not change the legislation, and there would appear to be an undertaking that there will be a separate chamber, and that will allow for separate training, etc. I think we're comfortable that the savings that there can be in terms of administration could be a good thing.
Thank you. Ms.
Yes. Similar position for the Additional Support Needs Tribunal. The Additional Support Needs Tribunal works very effectively in its current shape, but recognises that there are benefits from a Scottish Tribunals bill. However, those benefits will really only be achieved if all of those listed tribunals on the bill are actually transferred in. Otherwise, the haphazard and fragmented system that we currently have, which the bill is seeking to address, will remain. And in fact, we could end up having a far more diverse and haphazard system if the listed tribunals are not all transferred in as planned.
Conflict of interest in some of your tribunals sometimes where, and perhaps you'll explain to us, any conflict of interest of people who are hearing issues with regard to support for children with additional needs being part of the system?
There are provisions where there is a conflict of interest for a member, most usually an ordinary, a general member, not to sit, but those members that are part of the Additional Support Needs Tribunal will ordinarily not sit in the education authorities in which they serve or have served. Occasionally there may arise in the course of a hearing the question of a conflict of interest because the particular member has a background that is relative to the matter which is in the reference of the claim, and that's usually easily addressed by reminding parties of the scope and the capacity in which the member sits, and the fact that they sit as a judicial officer impartially and objectively reaching a decision based on the facts and circumstances.
Thank you. Just sometimes conflict of interest is mentioned. Mr. Beattie.
I would say that there are certainly benefits to come for our sector from what is proposed, but as Mr. Wright has already highlighted, it is unfortunate that these will only be available when everybody is brought into the unified system. And for some of us, that may be many years in the future. And therefore, the benefits of, for example, unified training across the sector will not be speedily accessed. I think the extent of the benefit depends on precisely how the structure is fleshed out, and this comes back to the earlier point that the detail is not there. For example, I very much welcome the suggestion in the written evidence by the Lord President that both the Valuation Appeal Committees and the Lands Tribunal for Scotland might be brought within the unified tribunal structure, but as separate pillars, with appeals against decisions of either tribunal in our major rating jurisdictions continuing to be by stated case to the Lands Valuation Appeal Court. If I understand it correctly, this would improve the perceived independence of valuation appeal committees by transferring responsibility for our funding and training from local authority to central sources. It would give our sector the benefit of judicial leadership and oversight by the President of the Scottish Tribunals. The continuing involvement of the Lands Valuation Appeal Court should ensure that the rating jurisdiction remains coherent, notwithstanding it is shared between the two tribunals at first instance. The Valuation Appeal Committees could retain their present regional structure, which ensures that members are people with local experience, which is very important in this jurisdiction. There would still, of course, be the difficulties created in our sector by the introduction of an age limit for membership, which we set out in our own written evidence.
Yes, thank you. I've got Graham, you were supplementary to this, then I've got John Finney and Alison after that. Thank you.
Thanks, Convener. I think partially Mr. Beattie has given some answer to my question. My question was that each of you have indicated that the current system works well, and that having read the paperwork, this seems a very complex area and pretty dense when you begin to go into some of the commentary that occurs with it. Could members, or would members, wish to tell me, from your perspective, what are the benefits going to be in going through all this pain? I've heard a bit about the unified training and this transfer of the finance from local authorities and the possibility of judicial leadership. Is that the extent of the benefits that are recognised across the various tribunals, or are there other points that you would want to make?
Yes, I'll take Mr. Dunsmuir first.
I suppose I'm reiterating what I've already said, and that the Additional Support Needs Tribunal works very well within its existing structure. And so perhaps some of the benefits will come from the sharing of expertise that's been gained through those tribunals which work very well. I'm aware that there are other tribunals which perhaps don't have the same resources available in terms of the delivery of training, for example. I suppose at the heart of all of this, we have to be very much concerned with the tribunal user, and the primary benefit has to be to the tribunal user, that they ought to be able to approach any of the listed tribunals and know with a degree of certainty the level of service that they can expect to receive. Whereas as it currently stands, tribunal users will have a different experience depending on the particular tribunal they may approach. And I think that this bill has to very much remain focused on delivering a service that is quality and clear in terms of the end user, and that's the tribunal service user. I think there's also a benefit from having an overarching leadership in the Lord President and a President of Scottish Tribunals. I think that that will improve the overall consistency of delivery of service across tribunals. There will also be an opportunity for generic training, but I think there is also a need for specific training given the diverse number of users that the tribunals serve.
Could I just suggest that even in the case of the Lands Tribunal, which I do suggest is in a somewhat different area, outside the area of administrative justice with which this bill is primarily involved, I think that there is benefit in expanding a system of purely administrative support, which has actually already started under the Scottish Tribunal Service. And mention has been made, I think, of training. I can think of one or two other areas in which that will assist. The recruitment process, for example, questions about conduct of tribunal judges and so on. These sort of things, I think, are undoubtedly benefits. But I would like to just distinguish them from the idea of standardizing case handling or that sort of thing. It's a very important part of our work, is the case handling, not just the hearing of cases, but the actual handling of cases by our specialist staff. And I really worry about sort of increasing standardization of that. But I do come back to suggesting that in the field of purely administrative support, there are real benefits in this bill.
The benefits I was highlighting, which you picked up, I think largely arise because I think uniquely out of the listed tribunals, my own is not structured on a national basis. The others have a single national organisation at present. For ourselves, we exist as 13 separate regional panels. Funded locally, although appointed by the Sheriff's Principal. And therefore, the guarantees of consistent operation and so on only exist within each panel area. I mean, in statutory terms, I mean, I'm only responsible for what happens in Highland and Western Isles. My position in relation to the other panels is as a purely voluntary organisation, the forum pulling all our panels together to have one voice to come here and speak with you and with Scottish Government. And the benefits of producing a national organisation would bring the consistency of standards across the sector, regardless of whether we were brought into the Unified Tribunal. And in a way, it would be a step that I think would have to be taken first before we could be brought in. And that's why in our written evidence, we suggest that before we might be brought into the system, that there ought to be a more radical, independent expert review of the sector to determine what really are the needs of the users in our sector, or the sector served by ourselves and jointly by the Land Tribunal, before a future framework is actually determined.
Thank you. As a supplement to that, and I'm sorry, I was digging around trying to find where I'd seen this, and it's in the Law Society's submission to us, which it talks about the distinctive character of tribunals, and oopsie-doopsie. And it says in their submission, the Society believes in the context of the proposed merger of the Scottish Tribunal Service and the Scottish Court Service, these characteristics, you know, and they're not all, I know they're not uniform across all tribunals, but informality, it's not a court, it's not generally, you know, for and against fighting each other, as it might be at Lands Tribunal, much more in the normal court practice, but the other way. It says we are important and worth preserving, they should be entrenched in the bill. So something should be said in the bill about the nature of a tribunal as distinct from the nature of court process. Is that silly? Is that pointless? Was it something you had seen it somewhere here, that it says Tribunals exist for users, not the other way around. No matter how good tribunals may be, they do not fulfil their function unless they're accessible by the people who want to use them, unless the users receive the help they need to prepare and present their cases. Tribunals should do all they can to render themselves understandable, unthreatening and useful to users. I exempt the Lands Tribunal at the moment from that. But do you feel there should be something along the lines of trying to embrace flexibility, but a culture? Yes, Ms Bailey.
Yes, I think it would be important that there's a recognition that as a forum for decision-making, tribunals do have a flexibility that is quite different and distinct from the court. In the case of the Mental Health Tribunal, the decisions about the detention of the mentally disordered has moved from the court to a tribunal. And I think it's important that it is recognised that that will continue to be the approach, a flexible, informal, patient-centred approach. I think it's very important.
Ms Dunsmuir, sorry, you want
Yes, I was just, I'm conscious that the Law Society's response reflects that of the AGTC in this matter. And I think it could go some way to reassure service users, stakeholders and service user groups if there was in fact to be something of a definition in the bill which describes the function of a tribunal and the distinctive nature of it.
Does anybody else wish to comment? Mr Beattie.
It is it's very much desirable that that distinction is brought out, but it is, I think, difficult to see just how it can be achieved given the breadth of the issues we as a group deal with and the procedures that are there at present. I mean, in my own case, the valuation appeal committees, for example, in our council tax jurisdiction are nearly always being faced with lay appellants who have to be handled as individuals and approached. In our rating jurisdiction, there are some lay appellants coming before us, but the vast majority of cases are handled by professional agents, and so it becomes a much more adversarial approach, and frequently we have senior counsel addressing us on both sides. So it is much more veering towards a court, and that is just within one tribunal in the different jurisdictions. So just quite how it could be enshrined, I'm not sure, but it is a worthwhile principle.
Mr Wright, just to...
May I just briefly mention that I've drawn attention to one, in my response, to one technique which is used in England and Wales, and I have some experience in relation to this, or in the UK tribunal system, which is the technique of an overriding objective. And that's put into the rules of tribunals, and I think it could be put into this bill, to enable tribunals. The overriding objective is to enable tribunals to deal with cases fairly and justly. And then you set out a number of particular principles in relation to that. For example, ensuring, so far as practicable, that the parties are able to participate fully in the proceedings. I'm quoting from the practice rules of the upper tribunal under the UK system. That, I think, is a useful device, and actually, I think it could apply in courts as well, but I think it is a useful device, and I did pick up in the response of Citizens Advice Scotland, focusing on this as a way of focusing on the needs of users. Yeah. But there are other principles to dealing with the case fairly and justly. One, for example, is avoiding delay so far as compatible with proper consideration of the issues. Yes. I think that sort of thing is the sort of general principle which could go into this bill. And for that matter, I would accept it for the Lands Tribunal as well. But,
yeah. We can always ask the Law Society to draft the amendment and submit them to members, as they've made a point, along with other submissions of this particular issue. Thank you very much. John Finney, Alison McInnes.
I'd like to address a remark to Ms Dunsmuir, please, and it's regarding an item in your evidence. It sort of leads on from that, and it's where you talk about your concerns about any, and I quote here, dilution of specialisms, or the culture and ethos, and that appears in a number of bits of evidence we have, and also when you go on to say any unintended drift towards generalised arrangements, and again that follows on from the standardisation comment earlier. I wonder, is that a preemptive comment about what could happen, or was there anything specific in the legislation that would give rise to believing that could be the case? No, Ms Dunsmuir, sorry.
Was it? Sorry,
Yes,
I didn't realise you were addressing.
But you were listening.
Yes, I was very much listening.
Yes.
The word drift caught me. Yes, I think the only way in which this bill can work effectively and deal with the range of concerns which already exist is to ensure that the listed tribunals are placed carefully into the appropriate chamber systems, and that in itself will help work against any generalised drift towards this generalised generic tribunal that everyone is so concerned over. And there are a range of safeguards, again, above that, which include that the Chamber President will be expert in the subject nature over which the President, the chamber over which the President presides. And I think not only the Additional Support Needs Tribunal, the Mental Health Tribunal and a range of others, including the Children's Hearing, Scottish Children's Reporters Administration, stress the importance of maintaining specialisms and preventing the dilution of those specialisms. And so I think that the careful placing in the appropriate chamber and ensuring that the Chamber President remains expert in that particular subject will be absolutely crucial in ensuring success and in preventing drift.
I think also the membership, the existing membership and the amount of investment that has gone into the training and development of the different cultures and different tribunals should be recognised. And the transfer in of members, existing members, is an important part of avoiding the development of a generic tribunal.
Right, I'm moving on now to Alison, followed by Elaine.
The bill provides for a common system of appointments to tribunals, and I'd be interested in the panel's views about whether or not you think that that will increase the independence of members of the tribunal in the first instance.
Well, I think it'd be an interesting development. I would find it hard to say that it would increase independence, because certainly in our case, I mean, we are appointed by the Sheriff's Principal, and therefore I would think that that was as good a guarantee of independence, frankly, as we could have. It's difficult to see that this would necessarily increase it. What I see as the greater risk from the common approach is that by having it straddling both the paid appointments that are in many tribunals and the unpaid appointments in others, such as my own, it may not be entirely appropriate to both. And in particular, the proposal that there should be a retirement age or an age beyond which no appointment can be made, I think may have a considerable relevance in the case of paid appointments and appointments where it is necessary to have people who are retaining up-to-date professional qualifications and experience. But I see it as less relevant in our own case, where we are laypersons with local knowledge, and it's a matter of knowledge of the local economy that you bring with, which is just as true of anybody at any age. And given that we do not have an age limit at present, the previous one having been set aside as being considered to be inconsistent with EU legislation, that if that were imposed before the next evaluation, we would lose 60% of our membership. Okay. And therefore we would lose that experience, very experience that it is useful to take into the new system. And where you find the successors, I don't know.
Thank you.
I'm glad it's a matter of capacity, not age, and there's no age limit on politicians. And yes, Ms. Bailey.
I think it's a welcome recognition that these are to be judicial appointments and that one appointment body can ensure that the tribunal skills that are specific to a flexible and user-centred approach are recognised as part of the appointment process. I think from that point of view, we would welcome the arrangements for appointment.
Hear from Ms. Dunsmuir first.
I agree with my colleague's comments there. I know that the JAB have made a comment in their response that there's no clarification over whether or not they would be involved in the reappointment process, and perhaps that's something that the bill ought to address, because the initial appointment is only one part of the scheme.
Yeah. That's helpful. The bill lays down the criteria for legal members, actually on the face of the bill, but it doesn't for lay members or what they call ordinary members. And that will be something that will come through in secondary legislation or guidance from the Minister. Is that an appropriate way to separate out the appointments?
At the moment, in the Additional Support Needs Tribunal, there is provision through regulations which specify the experience required before someone can be appointed to be a general member. One would hope that whatever the provisions in each of the listed tribunals, that there will be an arrangement to recognise the distinctive qualities necessary for individual tribunals. It would be disastrous if that were to be lost. That would go very much to the heart of the specialism of the tribunal, and I think that the bill has to address that much more clearly.
That's helpful, thank you.
Elaine, and welcome.
Maybe I should have actually intervened on this a little earlier, but because it's a fairly sort of general point, but for, as we've been describing, it's a sort of a generalist approach to the bill where the system is set up and certain listed tribunals become members, and then over a period of time others will also join. But in the evidence you've given, you suggest actually that some of the benefits won't actually accrue until the system's completely set up. I just wondered whether you agree that this approach of doing it in a gradual way was the best way of doing it, or whether in fact the whole system should have been set up with those tribunals part of that system defined from the outset.
It does have the effect, which Mr. Beattie has already referred to, that some tribunals may be left out of this for a long period of time. And indeed, if it is recognised that there are particular bodies, Lands Tribunal obviously is what I'm talking about, I know one or two other bodies like the Children's Hearing System have suggested they shouldn't be in it, then they will never get these benefits at all. So I do understand the approach of doing this on a gradual basis, but it does mean that parts which are useful just don't apply for a long time, and possibly never in the case of some bodies.
Rather than the Big Bang? No. Can I just say to the committee, because I know there's obviously much will be in subordinate legislation, that I've just checked that will be affirmative. So that we'll come back to committee, and for panel members may be concerned that, as we all know, the devil, as they say, and that cliche is in the detail, that will come back to committee to look at how it interacts with the primary legislation. Is there any further questions? I knew as soon as I said it, I must
there's two of us.
Just two. Roderick, I'll let you in first then. Because have you been in already, Graham? Yes. But it counts. Roderick.
I'd just like to quiz Ms. Dunsmuir about comments in the written submission in relation to appeals. In your written submission, you suggested that appeals to the Court of Session had worked well in practice. Under these proposals, appeals will go to the upper tribunal, which you say you're content with the bill's proposals, but perhaps you could expand a bit more about what you mean by content.
The process of taking an appeal to the Court of Session is undoubtedly expensive and can be fairly time-consuming. There can be quite some delays in the appeal process. the bill's provision that an appeal can go to the upper tribunal will remove those particular impacts. And in that respect, the President of the Additional Support Needs Tribunal is satisfied that the bill makes adequate provision and that there will be no loss to the Additional Support Needs Tribunal by virtue of this different appeals route.
So you would hope it would also be cheaper and speedier, would you?
Yes,
Yeah.
yes.
Okay, thank you.
Mr. Wright.
Yeah.
Would it be permissible just to point out that I do appreciate the usefulness of a tribunal hearing administrative justice appeals as opposed to going to the court? But again, that's something which just doesn't apply in relation to the Lands Tribunal. I'm not aware of any dissatisfaction in relation to the Lands Tribunal about appeals to the Court of Session, and indeed one particular positive area of Lands Valuation Appeal Court has already been referred to.
Thank you.
Great.
Thank you. If I've picked up, and I can't get the reference just now, but I thought I read in the evidence that the prospect was that the Scottish Tribunal Service will have a relationship with the Scottish Court Service, a growing one in the coming years. Is that something from your perspective you welcome? Is it something that causes you any concern? Is it of no event?
Yes, I'll take it. Who was first last time? I'll take Ms. Mary.
Okay. But I think to reiterate the route that cases that involve mentally disordered patients took to get to tribunals, the concern would be that we maintain within courts and tribunal service our specialism and a recognition of our ethos. And that extends to administration because those who are involved in the administration of cases involving the mentally disordered have built up a considerable expertise, both in terms of communication and in terms of the structure of the Act. The other issue would be in terms of venue. We would consider that to be a retrospective step for the patient to have to come to the tribunal. At the moment, the tribunal goes to the patient.
So just sort of following that, you would hope that this growing relationship with the Scottish Court Service would acknowledge that that's the current environment within which you work and service that environment rather than cause you to fit into their administrative requirements.
Absolutely. Yeah.
Thanks.
But there's no proposal for that to happen. No, it's just a concern, yes. And I think it'd be much the same. Yeah.
There is a consultation process underway at the moment regarding the proposed merger, and I know that each of the jurisdictions represented here today will have made responses in respect of that consultation. Sure. The Additional Support Needs Tribunal is an incredibly complex jurisdiction, and the level of specialism which the caseworkers have developed over the years would absolutely have to be maintained. I know Mr. Wright has already made comment about the level of specialism that's provided in terms of the administrative support to the Lands Tribunal. The President will report in the upcoming annual report the efficiencies that have been gained through the development of the casework process, and I would certainly hope that in any proposed merger the special knowledge of the caseworker will not be lost. And I know that the consultation process asks questions about how the board can be adapted to recognise the two different jurisdictions, and there will be undoubtedly comments to be made on that.
Thank you.
Mr. Beattie.
I would just say that for our sector, I mean, it is very difficult to see what the position will be, largely because we have got no indication as yet as to what the implications of being brought in would be for our secretarial and administrative arrangements. That at the moment, I think we are, I'm not sure, but I think we are pretty well unique in the tribunal sector in having an arrangement that we have lay chairmen and legal secretaries rather than the other way around, and a totally different administrative structure. So just how that will be merged into the new system, there have been no proposals as yet. We don't know. Therefore, what implications a further merger would be is just anybody's guess.
Might be an interesting question there for the Scottish Court Service.
Yes, are you coming back to ask an interesting question?
Well, hopefully I can encourage someone else to answer it, ask it for me.
I'm teasing you because Graham's leaving the committee and we will miss him. Can I thank you all very much for your evidence, very helpful, and I'm now going to suspend till, give them 6 minutes? Yeah. 6 minutes. Thank you very much. Can I welcome our second panel of witnesses? I know that you are sitting listening to the first set of evidence, and can I welcome Katie James, Advocard. Katie is the manager of Advocard's Individual Advocacy Service at the Royal Edinburgh Hospital. John Shaw, welfare rights worker, Child Poverty Action Group in Scotland. Lauren Wood, Policy Officer, Citizens Advice Scotland. And Ian Nisbet, Head of Education Law Law Centre. And can I thank for, again, written evidence submitted by any, and can I invite questions from members straight off. John, please.
Thank you, Convener, and good morning, panel. I'll start with the same question I started with for the previous panel, which was in relation to the bill, which is clearly about establishing a framework for reforming tribunals. I wondered if you share my concerns that so much of the detail is not in the face of the bill.
And you heard what I said, I think, about just letting me know if you want to answer, and I'll call you and your light will come on, microphone will come on. Ian Nisbet, please.
I mean, clearly, as has been said before, the devil will be in the details, and it would be useful, I think, for members to have at least some indication as to the likely content of subordinate legislation and guidance that is to follow. Having said that, I think there is something to be said for having the flexibility to make quicker changes where changes are needed. So for rules and questions about appointment and so on to be contained, as they often are just now, in regulations. I think there's nothing particularly objectionable about that, and it can be useful because the legislative timetable is such it's not always possible to get primary legislative slots where changes are needed, and there may well be, in bedding down a new system, the requirement for changes to tribunal rules. For example, the additional sport needs tribunals had a second set of rules that came out within a year of the first set of rules being published, because there were some minor amendments that needed to be made, and that wouldn't have been possible if it was all on the face of the bill.
No, the committee for primary legislation and not for secondary, and the process is much simpler and accelerated. Ms Wood.
I think we are definitely concerned by some of the lack of detail on the face of the bill, but I think there are ways that that lack of detail can be mitigated by, for example, including principles on the face of the bill to help guide tribunals as they are in the Tribunals, Courts and Enforcement Acts in England. I think another way to mitigate would be in terms of independent review, which I think is something that's missing from the face of this bill, in terms of giving the Civil Justice Council the function to oversee the process and procedures, but not the whole of administrative justice. And I know there are moves behind, in Scottish Government terms and also in UK terms to try and mitigate the impact of the Administrative Justice and Tribunals Council going. But I think in not putting on the face of the bill the power to someone to oversee administrative justice, there is the risk that all of the good intentions that are going on just now will be missed later on. In 5 years' time, will the intention still be to have a Scottish Government body as an independent advisory committee? I think another aspect of looking at this bill is also allowing for the development of new tribunals. And I think the potential for the Housing Tribunal is quite a good example to take when looking at this bill in terms of development. So I think, there's no way that you could put detail on the face of this bill about a housing tribunal that doesn't exist just now. No. But to include principles on the face of the bill and to give somebody the need to oversee administrative justice would mitigate any negative impact in terms of current tribunals, but also potentially developing tribunals.
Sure.
Yeah, I think I'd definitely echo most of what Ms Wood says there, and also to return to the overriding objective, which was really pleased to hear Mr Wright talking about in the previous session. There is something on the face of the Tribunals, Courts and Enforcement Act which places a duty to put the user at the centre of the tribunal system. And perhaps the concern is that while there is something similar in the Scottish Civil Justice Council Act, firstly, they've said they're not going to be able to start looking at drafting procedural rules. I think it was 2017-18, looking at the financial memorandum. And secondly, the policy memorandum says that there is no intention to significantly rewrite the rules. So in terms of placing an overriding objective at the heart of the tribunal system, which has been so helpful in terms of our area of expertise, which is reserved social security tribunals, I think that's a real area of concern. And in terms of a principle on the face of the bill to secure that, I think that would be a real improvement.
Ms. James.
I think from a service user point of view, the accessibility comes through people having detail that they can cross-examine, that they can look at, and that they can actually utilise effectively. They want to know the detail in order to be able to use any bill in the most effective way.
Just a sort of follow-on question to Ms Wood on behalf of the Citizens Advice Bureau. I mean, clearly, you support users of both devolved and reserved tribunals, and there's been very extensive reforms south of the border. And I just wondered whether there's any lessons that could or should be learnt from the experiences from the reforms that are already taken place for those reserved tribunals, and do you think the reforms in Scotland are, in terms of achieving efficiencies and getting a better system, are they meeting the same standard or the same, or what's been achieved south of the border, basically?
I think there are still a few questions to be answered about how efficiently things are working in terms of reserved tribunals. I think to have an echoed system is probably a very good thing for users, because in terms of what we find when somebody comes through the door, it doesn't matter to them whether something is reserved or whether it's devolved, or it doesn't
experience as MSPs.
It doesn't matter where it sits. They have a problem, they want their problem dealt with, and that's the focus. I think on those terms it is then essential that there is somebody to independently review the whole of administrative justice, including tribunal users. I think to restrict the functions that have been given to the Civil Justice Council to just process and procedures essentially could restrict what they look at in terms of how people access the systems. So I think there are still questions to be answered. We should strive for the best standard possible, because that's what somebody will experience. They don't care ultimately, even once everything's finished, that it's been reserved or devolved. But to have somebody to oversee the whole of administrative justice will be the way to make sure that things are good for people at the end of this.
I've got John Finney, followed by Roderick, followed by Sandra. John Finney.
Thank you, Convener. It's a question to Ms Wood. It's about a number of very stark comments in the opening section of your evidence, Ms Wood, about openness, fairness and impartiality, no guarantee as characterised by Franks, etc. Initially you talk about, without prescription of tribunal rules, fairness, openness and impartiality cannot be said to be guaranteed. Could you expand on that a bit, please?
In terms of the way that these are guaranteed, most of that is through the detail of procedure and process. And on the face of the bill, there isn't any detail about procedure. And so to then be able to say that the bill can guarantee that procedure will be open, fair and impartial, it can't. Because if there's no detail about the procedure, and if there are no safeguards like the kind of overarching principles to be able to guide the development of procedure in an impartial way, you can't, on strict reading, say yes, this will guarantee fairness, openness and impartiality, because the detail is missing to be able to offer those guarantees.
How would you suggest remedying that, please?
I think one way would certainly be in in providing principles on the face of the bill as a way of setting out this is the focus of what we want tribunals to achieve. So to be user focused, and I think in the submission on pages 3 and 4, I point out the principles that are on the face of the bill in the 2007 Act in England. Mitigating and by guiding the development of tribunals by principles, I think is the way to help to guarantee openness, fairness and impartiality.
That's page 4, by the way, of the submission.
Yes, indeed.
Yes,
Thank
for
you.
other, further members, I know
record.
you have
Yes,
just...
okay.
Yeah.
Thank you.
It's very helpful. I've got Roderick now, Sandra, after that.
Morning. My question is really addressed to Mr. Shaw. I take on board the point you made about the importance of the overriding objective. But just for the record, the policy memorandum, the government says there are no plans to comprehensively rewrite the rules of procedure. You make a number of comments in your written submission about the tribunal rules for the UK being simple and clear, but you also point out that you've no kind of experience for understandable reasons of the devolved tribunals in Scotland. I just wondered whether you were perhaps being a little bit sweeping in kind of taking the view that you were on the rules of procedure in Scotland if you don't actually have experience of the rules of procedure of the Scottish tribunals. I take on board the other points that you've made, but I just wondered whether you were going a little bit too far with it.
I think it's quite clear from our evidence that we're commenting on what we see as the positives of the reforms introduced by the 2007 Act. I would struggle to remember a point in the written evidence where it makes any sort of explicit criticism. I think it is clear that we don't see ourselves as in any way being expert in the devolved tribunals. I think the point we were hoping to get across was that there are real positives from that overriding objective underpinning the rules, and there being flexibility between the different specialisms and differences within the rules. And I'm sure that any system over time will develop down a road and be able to learn from the other tribunals. And in terms of how the tribunal rules, if they are drafted, that's not to suggest that there shouldn't be specialism, particularly in terms of membership, time limits, training, venues, as has been highlighted by the other tribunals. But there will always be an opportunity to involve stakeholders and users of tribunals and get the best out of each without compromising that specialism. So I was not intending to criticise the rules of any individual tribunal, but just to highlight that there is perhaps an opportunity to see where improvements can be made.
You do say, obviously, it's important as the rules or as the culture of the system, which I would agree with. But again, your experiences in the UK tribunal system, could you perhaps advise where you think improvements could be made to the UK tribunal system? You know, what can we learn from the experience of the UK tribunal system?
I think in terms of the UK system, a big issue, particularly in social security, is delay, which you will always find at a time of large-scale welfare reform. And there's potential that direct lodgement of appeals will eventually improve in terms of the delays within the system. One big improvement that was made when they drafted the procedural rules was preventing the automatic strikeout of cases where people didn't return an inquiry form sent by the tribunal service. And I think Judge Martin estimated that improvement led to 1,200 appeals being won, which would have been struck out simply for not returning a piece of paper. And certainly come October, we're going to see a removal of an extra stage in the process as appeals are lodged directly with the tribunal service. So that would be one area in which there is an improvement which is going to be made. I think actually reserved tribunals do work well, and there is a clear distinction between a tribunal and a court, and they do facilitate user access and particularly lay representation as far as the upper tribunal. So I think perhaps the one criticism would perhaps be that some judges do not necessarily have the soft skills, and there may be further opportunities to make appellants part of the process rather than feeling that you have an adversarial jurisdiction, which is perhaps a particular function of the fact that the Department for Work and Pensions will very rarely send a presenting officer, which leaves the tribunal judge to fulfil the role of cross-examining the appellant, it will sometimes feel like, depending on their particular interpersonal skills.
Thank you.
Thank you. Sandra.
Thank you very much, Convener. Like John, I think I'll pose my question, which I did to the other panel, and if I could follow up with some questions, please. Whether the proposals are an improvement and what we have before us just now, what we have. I note from Ms Wood's say it is an improvement, but also note the criticisms also that you've put forward. Maybe that's too heavy a word, but if I can open up and ask in general if you think these proposals are an improvement, and then I may follow up with questions.
I think the primary improvement that I would see in terms of the proposals from a user point of view would be in terms of accessibility. So the primary benefit of the tribunal system at the moment, or one of the primary benefits of the tribunal system at the moment over the alternatives of going to court, is that it's more accessible, it's generally cheaper, you can make use of specialist lay representation and so on. And the primary benefit that I would see of this new system from a user point of view is that that would be extended to the first tier of appeals, as it were, so that where people have had a tribunal decision that they disagree with, there's a point of law to argue. At the moment, very often that appeal, if the appeal right exists, is to court, and often to the Court of Session, and if you don't qualify for legal aid, then that is going to be out with the means of most people. And therefore, having the ability to take your case to the upper tribunal without those concerns and with the access to lay representation, specialist lay representation, then I think that is going to be good for users, but also good for the tribunal system, because many of the smaller jurisdictions don't have that flow of appellate decisions that can be very useful in terms of clarifying the law and process that the tribunals are using. So that I would see as the primary benefit from a user perspective.
Yeah, absolutely, yes.
I would actually concur with that, primarily because I think that people want at times some opportunity for mediation and negotiation, and I think that that upper tier would actually, when you look at it, give that opportunity for people to have more sense of an opportunity to negotiate and mediate effectively.
And also, I think, am I correct, that the referral, an appeal from the first tier, there's a sifting process in any event. I know it's hard for some people to accept a decision that may be blindingly obvious that the decision is the correct one, but there is a sifting process, and I take it you're content with that as well.
I have some concerns about the level of sift that is provided, and I noted in the Faculty of Advocates that they're concerned about the sift in terms of the second appeal, and yes. I think that would be something that needs to be monitored. I've no objection to a sift that is applied to cases that are obviously without merit, and I think yes. that is, as you say, addresses the concerns that you have, but there aren't a huge number of appellate cases being brought, and it is good for a tribunal system to have a reasonable flow of those. So I think that would be something that Parliament would want to monitor in terms of making sure that the sifting wasn't being applied too rigorously and leading to a lack of appellate decisions.
Yes, Ms Wood.
Yeah, I agree with all of the comments that Mr Nisbet has made, and I suppose I would also pick up a comment earlier that in terms of the new structure, it will also mean a guaranteed baseline standard amongst all of the tribunals, which I think is a very, very important thing for users. I think the tribunals, the way they've been allowed to develop in quite an ad hoc way, has been a good and a bad thing, because it's meant that each of the areas has developed into something that really does suit the users of each specialism. And so I think that it is an improvement to have a baseline standard, but each area should be allowed to retain its individual characteristics as far as possible. And I do feel that in allowing the development of a new tribunal, if it's to be developed within this structure, the principles on the face of the bill would give some degree of certainty that they should be allowed to develop in line with principles that put users at the core, but without necessarily having to develop in a really rigid way, which, again, particularly for a housing tribunal, I think is a very important thing.
And moving on. Oh, sorry, Sandra, I beg your pardon.
Chair, I had want to pick up on some of the issues, because I think everyone who put forward a submission has said it was an improvement, and then obviously as we went on with evidence, basically, you know, people have had concerns to a certain extent. I mean, Ms Wood, when you answered Mr Finney's question about guarantees, etc., you couldn't guarantee anything. Well, when you look at some of the figures which CAB has presented, it doesn't exactly guarantee here either. So I think there's a wee bit, you know, with words in this respect. I mean, you mentioned the 650,000 applications made to tribunals across the UK. Now, we're talking about the UK. And then you say the numbers continue to rise. And then you go on to say 2015-16 applications social entitlement chapter alone, which is another UK body, are expected. You know, it doesn't guarantee, they're expected. I'm just want to make the point that whilst you're asking for a guarantee on the principles in the face of the bill, evidence that you've presented here, or not you personally, obviously, that CAB is not necessarily guaranteed either. It's reasonable to expect words such as that. So I just wanted to clarify that point. And the other point I wanted to pick up with yourself is you mentioned about having another body because the CGS, but obviously we've had, I probably shouldn't say guarantees, but I think the Minister for Community Safety has expressed her commitments. I would say that was practically a guarantee for an expert independent advisory committee. Now, would you be content with that expert advisory committee, or are you looking to another tier as such again?
I think the Independent Advisory Committee, I think, is a fantastic move, and I should say that I've been I've been talking to the civil servants involved in that, and they've been excellent in their communication and their openness about that. I think my concern with that is the current independent committee will be an interim advisory committee, and that's the way that it's being discussed. And I think my concern is always the 5 years down the line test. So if there's nothing on the legislation that guarantees administrative justice will be overall reviewed, in 5 years, when this is further down the agenda, what will happen? I think in the last paragraph of my submission, I suggested that possibly that function could be given to the Civil Justice Council. But from my understanding of how the Civil Justice Council will work, and it is still very early days, that doesn't necessarily mean that they would have to be the ones to review. It means that they would have to be the ones to make sure that it's being done. Which is why in another part of the evidence I mentioned that it's unclear what the relationship currently between the Interim Advisory Committee and the Scottish Civil Justice Council will be. But I think that should be a strong relationship. I think on strict reading of the amendments to the Civil Justice Council Act, to insert the power to overview process and procedure, but not to insert the power to overview administrative justice, will mean that, reading between the lines, because they have the power to oversee civil justice, somebody else should do that, not them. And I think there is just a concern that if the power is not legislated and given to someone, then yes, the intentions are very good just now, and I think the Interim Advisory Committee will be a very positive thing, but it's just a question of how long will that last? How high on the agenda will that be for the next 5 years, for the next 10 years?
Yeah, I take, sorry, Chair, I take on board what you say, but things are certainly moving along, and next year we have the referendum for independence, so I'm just putting that part in. We're talking about 5 years, I'm talking about a year down the line, and I take on board exactly what you're saying. But it seems to be that whilst you say it's a good move, well, the proposal just now seems to be hemmed on this one thing that makes it not a good proposal, and I was just a bit concerned that it was very hung up on that one thing when there's so many other things through the tribunal, such as education, and perhaps somebody else will pick up on that with Mr Nisbet.
The AGTC next week, so we can marry that, your concerns about the interim period, and also what these functions will be of the should this other body take over. So we can raise all that next time. Alison, followed by Graham, please.
Thank you, Convener. I'm interested in the panel's experience of education appeal panels at the moment, and whether you think there would be a benefit to them being incorporated into a tribunal system. I think perhaps Mr Nisbet's well placed to deal with that.
Yes, thank you very much for asking. This is the part of the bill that I'm most excited about, in fact, is the prospect of moving the Education Appeal Committees into an independent structure. You're asking about what experience I've appeared before numerous Education Appeal Committees and advised parents who are appearing in front of many, many more. It's possibly one of the largest jurisdictions in terms of that list within the Act, in terms of the volumes of cases making very important decisions about children's educational futures. Its deficiencies are well known, have been recorded officially by the predecessor to the AGTC, the Council on Tribunals, for well over a decade. The Scottish Executive previously issued a consultation on proposed reforms, which I think didn't really progress matters, and the deficiencies that were marked in that original paper are still very evident. It is not an independent system, and it shows that it's not an independent system. The tendency of these committees is to confirm the authority's decision, and it varies between authorities. There's 32 different iterations of that, and some authorities are better than others, but by and large there is that tendency, and in some cases without any serious scrutiny of the case, simply to maintain. So the prospect of having that jurisdiction brought within an independent tribunal service, as I say, is one of the most exciting and one of the biggest beneficial parts of the bill, I think, that we'll see.
That's very helpful. Is there also, would there be an opportunity to have a shared chamber with the additional support needs?
Yes,
at the same time, does that bring further benefits?
My apologies for interrupting. Yes, I've no reason to object to that. I think that is a good move, that a learning chamber or something of that sort would be very beneficial. The members of the Education Appeal Committee are not specialist members, and they are counsellors and parents, and there's an element of choosing, but certainly when it comes to more complex issues of exclusion or placements for children with additional support needs, either in mainstream or special schools, that expertise isn't there, and this would represent an opportunity to develop that, I would think.
Okay. And just finally, Glasgow City Council have made a submission, and they've obviously pointed out that most of the appeals happen at one particular time. Do you anticipate any particular problems with that?
I mean, certainly that's true that there is a large seasonal element to this, because most placing requests across Scotland are all decided at the last day of April, and then the appeal process kicks in, and local authorities are aware of that and have to set themselves up to deal with it and do it very well in terms of bringing through. I know that the Additional Support Needs Tribunal, to a lesser extent, can experience some of that, and obviously you don't want the situation where parents are unaware of which school their child will be going to until sometimes into the new term. We've had cases that go to the appeal committee and then to the Sheriff Court, and by the time you're through that process it can be into August and so on. So particular attention would need to be given to that, but as I say, the appeal committees at the moment, in terms of getting that throughput, certainly do a good job, and there's provisions within the legislation to allow cases to be heard together if there's a number of cases for the same school, to be at least part heard together, so that you don't have to hear the evidence about how many classrooms and how many teachers and so on more than once.
Okay, thank you, Convener.
Graham.
Thank you. Just to pick up on a point that we heard at the earlier panel, one piece of evidence indicated that the notion of an age limit at 70 would have a fairly substantial impact on the capacity of that particular administrative process to maintain in the years ahead. From your own experience in these different administrative appeals and tribunals, would an age limit have any effect at all, or do you have any opinion that you'd want to share in terms of the limit that one would put to someone who's appointed in that judicial capacity?
Stunned silence, all of that.
Good.
Mr. Pearson.
In terms of the jurisdictions that we appear in, certainly that both the Education Appeal Committees and the Additional Support Needs Tribunals do seem to rely heavily on retired professionals in terms of the membership. So it could well raise an issue in terms of cutting off a potential supply of members.
I'd certainly echo that in terms of the social entitlement chamber. Quite often the specialist medical members are retired general practitioners. So it could have an impact as described by Ian.
And your experience of what either they bring to the process or fail to bring to the process, do you have a view in that matter at all, or would you prefer to remain silent?
No need to remain silent. I mean, certainly I think in terms of parental confidence in the process, to have somebody who is no longer within the system working for a local authority and so on actually enhances their credibility as a member and so on. So it can actually be a benefit.
We'll put it down to quality of years, not quantity of years,
Indeed.
Graham, I think,
Indeed.
yes. And you would agree about age. Now, are there any further questions? I have no other questions, so can I thank you very much for attendance. It was very useful. If you think of something later that you want to add or some comment on subsequent evidence, please write in to the committee and we can do it, because obviously we'll have evidence next week that you may feel you want to say something about. Thank you very much. Move on to item 3 in the agenda. I'm just going to move straight on. It's on EU issues. Paper 7 provides an update on the committee's EU priorities that we agreed at the beginning of the year. And I'll pass straight on to Roddy to ask him to lead on that, please.
If I can just kick off by saying a few words about the question of the opt-out and whether or not the UK government will finally opt out of the pre-Lisbon Treaty 130 measures. The paper is reasonably self-explanatory. We knew from October last year that the coalition government was minded to opt out, and then the House of Lords committee prepared a report in April which was critical of the government's decision in that respect. And since then, the most significant development is the announcement on the 9th of July, where Theresa May, the Home Secretary, announced a list of 35 individual measures that the UK government would seek to rejoin should the opt-out be exercised. But there is still some way to go with this. The House of Lords subcommittee will no doubt be looking at this further. It seems to me it's obviously a highly controversial area. That's a matter that this committee would benefit from looking on and taking some kind of evidence in due course without wishing to completely duplicate the very valuable work that's going on at Westminster. So it's really a question of what this committee wants to do on it and when. And obviously we need to do it in time to if we're going to have any impact on the final decision. My own kind of view is if we could find a time slot, I don't know, towards the end of the year or in January, to do something then to take account of the developments by then. As far as the 35 specific measures are concerned, I don't want to preempt things, but I don't think there are specific items that I would say were overly relevant to Scotland. There are quite a lot of Schengen measures and well, there are 5 Schengen measures and the rest of them are non-Schengen measures. But I mean, there will be some clarity. As I say, the main issue for this committee is obviously we have a heavy workload already and want to avoid just doing things for the sake of it, but I think we do need to have some input in some form in relation to this matter.
John?
Thank you, Convener, and thank you to for that update. In the letter there, it referred to a seminar on the 5th of June. I note Rod talked about was it House of Lords meeting in July. I just wonder if there were more on the specifics, because you know, whilst I'm pleased that the Lord Advocate and faculty advocates, ACPOS and others gave evidence, they were very strong as their concerns that they voiced about the implications for international cooperation on criminal inquiries. So if we could maybe just know where we are with the specific things they are prepared to go along with, that would be helpful. Thank you.
I mean, so they did give it. There's a clear difference of opinion with UKIP and various individual Tory backbenchers, obviously having very strong views about it, and obviously the
Delighted to hear there's that difference, yes.
Yeah, the background to...
It's not here. John's not here to defend the case.
No, and the background to kind of European issues anyway, because we've got European elections next year, so I mean, it's an ongoing issue. It's a question of when would be the most appropriate time for us to stick our more into it.
If I may, on appropriate times, come in here and say, can I ask you these proposals, because we can discuss this in January. I'm looking at, you've got your forward programme, and sometime between maybe January 14th, probably, round about January the 14th. So what I propose to ask you to agree is to note the developments in relation to UK Government's 2014 opt-out decision, and we'll continue to monitor these developments, including the House of Lords inquiry. To note the developments in relation to the proposal to establish the European Public Prosecutor's Office, and we've already made a statement about what we think about that, because we've moved on. I mean, we've put a motion down. And to return to the final two priorities once full details of the proposals become available, which makes sense. And we can come back to that in January when obviously there's a lot still going on. Are you agreeable to that, John?
Thank you. I think that would be helpful to hear. I just wonder if in the interim, if there were developments, if we could be kept appraised of these, please. That would
yes. Okay. Right, thank you very much. Our next meeting is on the 10th of September. We'll hear evidence from the Cabinet Secretary for Justice on the LCM, on the Antisocial Behaviour and Policing Bill. We'll also hear from a further panel of witnesses on the Tribunals Bill. And can I say to you that you've got your list in front of you of what lies ahead. Perhaps it's too much for you, Elaine, and you're not going to bother coming back. But what I would also say to you is, I'm suggesting to the clerks that what would be useful also is to have a note of when amendments have to be in at stages 2 and 3 for various members. Just saves us if it's put on, then that's helpful to you all. Okay, that's fine. Well, that concludes the meeting. Thank you very much.